If you are a resident of New Brunswick who is legally married and has experienced a breakdown of your marriage, you may be able to file for a divorce on your own without the assistance of a lawyer. How can you know if you qualify for this option? This video will help you answer that question. To start, consider how you would answer these 4 questions. Is your reason for the divorce that you have separated and expect to remain separated with no chance of reconciliation for at least 1 year? Have you or your spouse, or both, been living in New Brunswick for at least 1 year? Do you know where your spouse lives so documents can be served on them? Is your divorce uncontested? This means you do not expect your spouse to oppose the divorce because the questions related to parenting time, decision-making responsibility, support, and property matters are settled between you. If you can answer yes to all these questions, then filing for your divorce on your own is an option you can consider.
If you pursue this option, it will cost between $260 and $440, depending on your access to a photocopier, your arrangements for serving the divorce documents on your spouse, and fees related to filing documents, oath-taking, and the release of the certificate of divorce. It will also be necessary for you to demonstrate that there has been a marriage breakdown with no chance of reconciliation. This can be demonstrated in 3 different ways. 1. You and your spouse have separated. You can start the divorce process by filing an application or petition at any time after separation. But you must have been separate and apart for at least 1 year before you can file a trial record to request the court grant the final divorce. 2. The respondent spouse in the divorce proceedings has committed adultery, and this can be proven. 3. The respondent spouse has treated the applicant or petitioner spouse with physical or mental cruelty, making it intolerable for the spouses to stay together. If you are filing for divorce due to reasons 2 or 3, it is recommended that you hire a lawyer. Petitioning for divorce because of separation can be done yourself. This reason does not require you to prove who is at fault for the marriage breakdown.
Before you explore the steps to file for divorce, you need to understand some things about the rules of court. All procedures related to the divorce filing, including how documents must be prepared, how much time is allowed for a response to the filing, and how the documents are to be served on your spouse, are all determined by the rules of court. You must carefully follow these rules. They are in place to ensure a level playing field for everyone involved, so everyone doing a divorce needs to be familiar with these court rules. Rule 18. Service, if you're required to serve documents. Rule 72, divorce proceedings. Rule 73, family division. And Rule 81, family law rule in the judicial districts with a case management model, Moncton and St. John. Depending on circumstances, some others may also need to review the following rules. Rule 37, procedure on motions, and Rule 74, Marital Property Act applications. These rules have been made available to you on the Government of New Brunswick, GNB, website. On the GNB website, rules of court are available under Acts and Regulations, or by searching them in the search bar on the main page.
The rules of court are accompanied by the forms of court. These forms are available for a fee from the Registrar's Office, court offices, a Family Law Information Center, St. John or Moncton, or Service New Brunswick, or the NB Office of the Attorney General website. The forms you require will be identified in the following steps.
There are 7 steps to follow when filing for divorce on your own. The first is to prepare your petition or application for divorce. Once you obtain the correct form, gather the documents that must accompany the petition. These include your original marriage certificate, the separation agreement and any related court orders, if there are any, and your financial statement and other income information. In some instances, the court may require 3 years of income tax information and notices of assessment, reported using Form 72J. Ensure you complete all forms correctly. The Doing Your Own Divorce in New Brunswick guide will help you with this task. It includes sample divorce applications and petitions in Appendix B. To complete this step, check to see who you can retain as a Commissioner of Oaths if you are including a financial statement, Form 72J. You are required to swear to the truthfulness of the financial information you have compiled and include a certification of your oath with the petition documents.
The second step is to file the application or petition for divorce and its attachments. This step will require you to prepare a cover letter and a large self-addressed stamped envelope. You can view a sample cover letter in the Doing Your Own Divorce in New Brunswick guide. Make 2 photocopies of all your documents. File the original and 1 copy with the registrar, and keep 1 copy for your records. Your filing must include a certified check or money order for $110, payable to the Minister of Finance. The payment amount will include the filing fee and the fee for the clearance certificate. This certificate is not a divorce judgment, but is proof from the Central Registry for Divorce Proceedings in Ottawa that neither you nor your spouse has previously initiated divorce proceedings in New Brunswick or anywhere else in Canada. Be aware that the filing fee may be waived if you receive social assistance and if you include with your petition a recent note from your caseworker indicating you are currently receiving assistance. To complete this step, gather all these documents, the cover letter, envelope, and payment into a single package. Since you cannot e-file these documents, either mail the package to the address shown on your screen or deliver it in person to the registrar's office at this address shown on your screen.
The third step is to serve the divorce petition or application and its attachments on your spouse. This step is not needed if you use the Joint Petition for Divorce Form 72B. Begin by making 2 copies of the original documents returned from the registrar's office. Keep the original for a later step and the second copy for your own records. Your spouse must be served within 6 months of the date your petition or application was received by the Deputy Registrar's Office. Since you cannot serve the other party yourself, there are 3 ways you can do this. Personal service can be done by an adult friend or relative, or you can hire a process server, such as the New Brunswick Sheriff's Office. You can have someone serve the documents by registered mail. If you cannot find the other party, you may have to make a motion to the court for substituted service. Here, the court may order you to serve the documents electronically by email or social media, for example, or through a relative of the other party. The court may even waive the requirement to serve in exceptional circumstances. A final method of service allows you to do it yourself. Service on a lawyer allows you to serve on the lawyer who is representing the other party. The documents can be physically given to the lawyer or faxed to them. Once the other party has been served, you must wait for them to reply. The time allowed for their response is based on the divorce form you used. Form 72A allows 20 days if they live in New Brunswick, 30 days if they live elsewhere in Canada or the U.S., or 60 days if they live elsewhere in the world. Form 81A allows 20 days if they live in New Brunswick, 20 days if they live elsewhere in Canada, or 40 days if they live elsewhere in the world. If the other party does not file an answer, Form 72D or 81C, or an answer and counter petition, Form 72F, within the allowed time, then they are deemed to not be contesting the divorce. If the other party responds and raises a claim related to parenting time and decision-making responsibility, support, or property, you should seek legal advice. The divorce will then be contested rather than uncontested and require a court hearing. If your spouse is not contesting, but the divorce involves financial support, they must serve you with their financial statement and income information, including 3 years' tax return and assessments and recent pay stubs. To complete this step, you must be clear about the nature of the response from the other party, and the person who served your ex-spouse must complete and sign an affidavit of service, Form 18B, before a commissioner of oaths. For more information on completing the affidavit of service, refer to the Doing Your Own Divorce Guide.
The fourth step is to prepare the trial record. This is a package of all the relevant documents you must file with the court to demonstrate you have followed the steps required in the divorce process. In an uncontested divorce proceeding by affidavit evidence, no hearing scheduled, the trial record must include the following: a cover letter, a cover page for the trial record, an index, a certificate of readiness, Form 47B, a request for divorce, Form 72K, the clearance certificate from the Central Registry for Divorce Proceedings, an affidavit of service, the original petition or application for divorce and attached documents, and either an affidavit of evidence or an affidavit supporting joint petition. If you are filing an affidavit supporting a joint petition, both parties must make arrangements to sign before a commissioner of oaths. When you have prepared your trial record, you are ready for the next step.
When you have prepared your trial record, you're ready to take the fifth step, filing the trial record. You must file your trial record within 5 days of having sworn your affidavit of evidence before a commissioner of oaths. If you are using a joint petition, you must file it within 14 days of signing. File the trial record with the Court of King's Bench Family Division in the judicial district named at the top of your petition or application for divorce. Do not send the trial record to the registrar's office, and be sure to make a copy of all documents for your records. Once your trial record has been filed, you now wait for your divorce judgment. Here's what is happening while you wait. The clerk or administrator of the court submits the trial record to the judge. The judge reviews the trial record and affidavit of evidence to make sure you have included all necessary documents and that all information in the trial record is accurate and complete. It must also support the request for divorce and any related orders relating to parenting, decision-making, and support. This is called an assessment of the request for divorce. There is usually no court hearing when you choose to proceed by affidavit evidence. To complete this step, you need patience. It could take 4 to 6 weeks to receive a divorce judgment for an uncontested divorce. This timeframe could be longer if there were errors or omissions in the documents, and the trial record may be sent back to you for corrections if it was not prepared correctly. The judge may also decide the divorce requires a court hearing.
The sixth step begins when you receive the divorce judgment, an initial ruling approving your divorce. This judgment is not yet the divorce itself. It is a notice of the date your divorce will take effect. Both parties will receive a copy of the divorce judgment from the registrar. It will also include any order for corollary relief, such as child or spousal support, that the judge ordered. If you have not received your divorce judgment within 2 months of filing your trial record, You can call the clerk or administrator's office in your judicial district to check on the status of your divorce. Unless both parties have signed an agreement not to appeal, Form 72L, and the judge has ordered the divorce to be effective immediately, there is a 30-day appeal period beginning from the date the judge signed the judgment. Either party can appeal the judgment during this period. If neither party appeals during this period, then on the 31st day from the date of the divorce judgment, your divorce is in effect, and this step is complete.
The seventh and final step is to apply for your certificate of divorce. This document is proof of your divorce. It is not sent to you automatically, but you can apply for it 31 days after the date of the divorce judgment by either mailing or hand-delivering a letter requesting the certificate, along with a certified check or money order for $7, payable to the Minister of Finance, to the Deputy Registrar, or applying through Service New Brunswick, SNB. This can be done by applying in person at an SNB center near you, or by ordering it on SNB's website.
Working through a divorce can be difficult and emotionally draining. You can avoid making it even more difficult by carefully following these 7 steps. They will ensure you follow the rules of court during the process and maintain a level playing field for everyone involved. For more detailed information about the process outlined in this video, please visit us at the web address shown, or use the contact information to reach us. This video is intended to provide general information only and should not be construed as offering legal advice about your situation.